Every state in the U.S. has animal cruelty laws, but very few animal cruelty cases are brought to court. If we all agree that animals should not be abused, why aren't these laws better enforced?
The first state criminal laws to protect animals were not cruelty laws, but private property protection laws. You see, animals were and still are considered legal property. And as state legislatures were enacting laws, an injury to an animal was seen only as a legal injury to the animal's owner. Specifically, it was only illegal to injure an animal that belonged to someone else, and the law only applied to commercially valuable animals like horses and cows. There were no prohibitions on abusing your own animals or prohibitions on abusing animals that had no monetary value, like dogs.
In the 19th century, the evolution of state statutory laws paralleled the evolution of societal views towards animals. Laws began to prohibit cruelty, signaling an acknowledgement of animal suffering, and abuse became illegal, regardless of who owned the animal. But the definition of which animals were covered remained narrow. Some theorized legislators simply included the list of animals they were familiar with, not seeing the connection that if it's wrong to torture a cow, it should also be wrong to torture a dog or cat.
But historically, there was still a large contingent of legislators who supported animal cruelty laws not for the benefit of animals, but because cruelty harmed people. They were worried animal abuse would escalate into violence against people. The level of concern over animal cruelty can be surmised by determining if the state defined it as a criminal offense and looking at the severity of the punishment.
Criminal law governs the conduct that society deems so serious that the actions are not simply a matter between private parties, but it additionally involves the community as a whole. Murder, theft, and assault are all examples of actions that affect a community.
In modern law, criminal cases are almost always initiated and run by the government and have a high burden of proof. There are, however, a variety of laws that authorize private parties to initiate criminal charges, petition courts to order criminal activity stopped, or handle other portions of criminal cases.
Criminal sentences are exclusively enforced by the government and can include restitution paid to the crime victim, prohibitions on future conduct, programs aimed at addressing underlying causes of the crime, fines paid to the government, and incarceration.
Civil law governs behavior that results in harm to an individual or private party. Breach of contract, personal injury, and property damage are examples of actions that typically only affect the parties involved. Civil cases are initiated by a private party that has suffered an injury. This can be a financial injury, a physical injury, or an aesthetic injury.
The penalties are typically limited to a monetary award, and if applicable, a court order to stop doing the thing. But without clear explanation of what statutory laws were enacted to address, much is left for the court to interpret, and those interpretations result in case law.
In both criminal and civil areas of law, a patchwork of inconsistencies from state to state continues. Each state's laws have their own ambiguity and are open to court interpretation. Even today, legislation can be passed on behalf of animals in order to protect them, but does not explicitly say animals are the subject of the law, or that the purpose of the law is to prevent or redress animal suffering. Our legal system is very human-centric.
Without specificity, the fact that a law affords animals some protection can seem incidental. It can be interpreted that these laws are passed for the benefit of humans, because we don't want to see animals suffer, as opposed to laws being passed explicitly to prevent animal suffering, because animals should not suffer by human hands.
Unfortunately, the U.S. legal system has not kept up with society's attitudes towards animals. 70% of U.S. households have at least one dog or cat, and many of us consider them family. Regardless of species, science has shown us that all animals are individuals and have unique traits.
As a society, we all agree that no animal deserves to suffer, and that animals have their own inherent interests and value. But just as early statutory laws largely criminalized abuse against animals who had commercial value, today our legal system regularly reduces individual animals' lives to a market value.
Avery escaped from his Texas backyard. He was picked up by animal control and mistakenly added to the euthanasia list. When Avery's family came to collect him, they learned his fate and filed a lawsuit to recover damages for the tragic negligence. Usually, courts award the market value for destroyed property, but Texas recognizes sentimental and intrinsic value for special property, like family heirlooms. Avery's family asked to recover his sentimental value because they specially valued him due to his unique personality and deep bond with the family. The case eventually reached the Texas Supreme Court. The court acknowledged dogs are beloved friends, confidants, and even family members, and that a companion dog is not an inanimate object like, say, a toaster. But the court was, nonetheless, unwilling to recognize an animal's actual value to their loved ones, and instead adhered to the traditional market value. In a macabre twist, the Texas Supreme Court acknowledged that Avery would have been worth more to the law as a taxidermied heirloom than a living member of his family.
This type of strict economic evaluation of personal property fails to distinguish the distinct difference between animals from inanimate property like a chair. Many also argue that this economic evaluation does little to deter profit-driven crimes involving animals, such as theft of companion animals, wildlife trafficking, and illegal hunting. But some more recent laws outright acknowledge that some animals have independent interests outside of our human interests.
Until recently, in divorce or dissolution proceedings, cats and dogs would be divvied up with the pots and pans and area rugs. Which person paid the veterinary bills may have tipped the scales one way or another. But in 2016, Alaska became the first state to pass legislation that requires judges to consider an animal's interests when determining their placement, including the option of joint custody. And many states have since passed similar laws, with additional states' judges taking animals' interests account, even if not required by law.
Since the first sweeping federal animal protection law was passed in 1966, public support for animal protection has remained high. But in reality, there are very few animal protection laws on the books, a lot fewer than what the average person thinks there are. And the animals protected by those handful of laws have flipped since the inception of animal cruelty. Dogs and cats and endangered animals now enjoy more protections than any other animals, and cows all the way at the bottom. In many states, routine practices carried out by farms are exempt from animal cruelty laws, which feels like an acknowledgement that what is routinely happening to cows and other farmed animals is cruel. But regardless of the species, the laws that exist are dramatically under-enforced. Why? Because the way these laws are written, not just anyone can enforce them.
It's typically up to the government to enforce criminal cruelty offenses. With limited resources and large caseloads, expensive experts, complex forensics for misdemeanor or low-level felonies, and a victim who can't testify, few animal cruelty cases are pursued.
But there are a few exceptions. For example, Ohio has a statutory law authorizing private prosecutions, allowing humane societies to appoint an attorney to prosecute animal cruelty crimes. A few states allow citizens to petition the court and to impanel a grand jury to evaluate if there's enough evidence to charge an individual for a crime and to get the ball rolling. But it's still ultimately up to prosecutors to take action.
On the civil side, there's a general formula of substantive and procedural rights to determine who can file a lawsuit. 1, the court has to recognize the plaintiff's ability to sue. 2, the violation of a law. And 3, the court needs the ability to remedy the violation. You need all three.
In Iowa, a couple held hundreds of animals on their property, operating a roadside zoo. Lions, tigers, and bears lived in rusty corn cribs. Conditions at the zoo were grim, and animals' most basic needs of food and water were not being met. The zoo was violating the Animal Welfare Act, the Endangered Species Act, and the state cruelty code, resulting in the animal's injury. Boom, violations of law. A judge certainly has the ability to enjoin cruelty from happening and order the removal of the animal from the abusive situation, so the court can provide a remedy. Boom, remedy. But so far, the only parties involved are the zoo owners and the animals who are being abused. The government has declined to take action. Can a third party step in to represent the animal's legal interests?
Now, the mere mention of the idea of an animal being able to bring a case to court typically quickly devolves into jokes about dogs having the right to vote, getting driver's license, or suing for not getting enough treats. But remember, We're talking about existing statutory laws, including some passed by Congress and signed by the president, which are overwhelmingly supported by the public. But in this scenario, and almost every other legal scenario, courts have yet to recognize animals' legal interests to protect themselves. Given the lack of laws protecting animals and the obstacles to enforcing those laws that do exist, the Animal Legal Defense Fund has to be creative in meeting the 3 basic requirements for filing a civil lawsuit. Sometimes even using laws that have nothing to do with animals to help animals.
We've used anti-gambling laws to shut down coyote killing contests, consumer protection laws to challenge puppy mills, environmental laws to protect wild animals. And in the case of the Iowa Roadside Zoo, we pointed to the negative effects to the community and used a nuisance statute to argue for the enforcement of animal cruelty laws. The zoo was shut down, and 400 plus animals were transferred to rescue groups and reputable sanctuaries. A civil lawsuit is limited to stopping the illegal behavior and does not impose criminal punishment, but stopping the animals' suffering and arranging a safe place where they could live out the rest of their lives was the priority.
Due to procedural requirements, in each of these cases, the courts required that a person was injured by the illegal activity. With the legal maneuvering, we were able to arrive at the desired result. But should it be this hard? How effective are animal protection laws at protecting animals if they are so hard to enforce? The Animal Legal Defense Fund is working to enact more and better legislation with clear avenues for enforcement. But we're also working to expand courts' recognition of animals and their interests.
Justice is a victim of neglect so severe that he will require specialized veterinary care for the rest of his life. His abuser pled guilty to criminal neglect and paid restitution for Justice's veterinary bills up to that date. But Justice's expenses didn't stop accumulating. And while Justice is lucky, other victims of abuse may be euthanized if no one volunteers to adopt them and assume their ongoing veterinary expenses. But Oregon case law has already established that individual animals are crime victims, and standard negligence law allows injured parties to collect damages from the wrongdoer. So the Animal Legal Defense Fund filed a lawsuit on Justice's behalf against his abuser to collect the funds to provide for his ongoing care. Justice's expenses are the direct result of his abuser's criminal activity. If Justice qualifies as a crime victim, shouldn't he be able to collect?
The Colombian government announced that it was considering a plan to kill hippos, who are the descendants of animals illegally imported by Pablo Escobar in the 1980s. An attorney filed a lawsuit in Colombia on behalf of the hippos to intervene. Serving as U.S. counsel, the Animal Legal Defense Fund petitioned a federal court requesting subpoena power to depose wildlife experts in the U.S. on the hippos' behalf. The application was granted, and for the first time, animals were recognized by a federal court as having their own legal interests.
Both of these examples have narrow and limited scopes, but they demonstrate a continuum of varying degrees of court recognition. Animal legal status can be thought of as having multiple dimensions. One is the interests laws provide to animals, and the other is how the law actually allows those interests to be enforced. We can illustrate the current legal status of animals with one axis as the substantive protection. This includes everything from not suffering cruelty by humans, to not being driven to extinction, to being treated as someone rather than something during a divorce case. The other axis is enforcement. This includes the animals themselves being able to sue, like in Justice's case, the government enforcing a criminal law, or a person or organization having the ability to enforce laws on the animal's behalf. Procedural and substantive rights need to work in tandem to be able to enforce rights through the court.
It may be surprising that just because someone is violating the law doesn't mean that anyone can file a lawsuit to stop them from doing it. What may be more surprising is, depending on the law and its definitions, some animals may not qualify as animals. In the legislature, elected officials draft and propose bills, and then as a group, vote in favor or against them becoming laws. These are statutory laws, regularly referred to as statutes. Some bills are one sentence long. Some are thicker than a phone book. Some are well thought out, and some are poorly written.
When a bill is drafted, it usually has an introduction that outlines the intention of the law, and there is usually a list of definitions to clarify the bill's scope and intentions. Sometimes the bill outlines who can enforce the proposed law, and sometimes it doesn't. Each statute can have its own definition of animal, and that definition does not always adhere to commonly accepted biological and cultural understandings of what an animal is. Fish and aquatic animals, cold-blooded animals, and wild animals are sometimes excluded by state cruelty law definitions.
A North Carolina man was arrested and charged with 4 animal cruelty charges for failing to provide his Oscar fish with food and water and abandoning him when he was evicted. The fish was malnourished, swimming in a dirty tank, and suffering from parasitic disease when discovered by authorities in the abandoned residence. The following week, however, all of the charges were dropped. According to North Carolina's animal cruelty law, fish are not animals. The state's animal cruelty statute defines animals as every living vertebrate in the classes Amphibia, Reptilia, Aves, and Mammalia, except human beings. Fish are not represented in these categories and are the only vertebrate class not included. In addition, as with other animals, the cultural category into which they are placed matters. Being classified as a pet versus food or a research subject will yield different levels of legal protection. As a society, we don't want animals to suffer, unless we want something else more.
To increase animal protection and enforcement, it is critical to know the weaknesses so they can be strengthened, to see the opportunities so they can be leveraged,
And confront cruelty by holding industries, individuals, and the government accountable.
The advances that the Animal Legal Defense Fund is making for animals are strategic, innovative, and hard fought. Will you represent animals? Sign up at aldf.org/join.